Yep. All right. Court of Appeal and for the state of Florida is now in session. Honorable John K. Starkville, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to this session of the 6th District Court of Appeal. There will be 2 cases today, but this panel will be hearing the first one, then we'll take a brief recess and pick up with the other case from there. Would like to ask everybody to please turn your cell phones to silence at this time. And the first case that we have, well, let me introduce my colleagues. We have to my left is Judge Pedro Brownlee. My right is Judge Jared Smith, Judge John Starkville. We will give each side 20 minutes. How much rebuttal time would you like to reserve?
3 minutes, John.
3 minutes? Okay. Okay. Yeah, I may have to just use my phone doing the whole cross appeal thing, but yeah, we'll figure this out. All right. Well, there's nothing further. Counsel, you recognize.
Good morning, Your Honors, and may it please the court. The post-conviction court below explained that but for a 5th District precedent would have denied post-conviction relief on defendant's ineffective assistance of counsel claim, and instead followed the 4th District's reasoning from Stone. It even went out of its way to notably state that, quote, newly constituted 6th District will have an opportunity to weigh in. This court may properly deny defendant's claim. Defendant was not entitled to the good faith instruction, at the very least, because the cases he relies on, in those cases, the defendants were arguing that they had a mistaken belief that made them think that they could possess the victim's property. While here, he's arguing that he's far from it, that he purposely did everything he did, but simply because he was honestly trying to start a business. But even across the board, we believe that a defendant was not entitled to any type of good faith instruction, because the defense is just an argument that the defendant did not have criminal intent. No reasonable juror needed to be told that there's no unlawful intent if you're acting honest. In this case, allegedly to start a business. And even if this court doesn't agree with all that, the lawyer would not be grossly incompetent under Strickland coming to those reasonable legal conclusions. I'll start by going into a little detail about why we think he was not entitled to the good faith instruction. As I mentioned, at the very least, or I'll start actually with our frontline position, that it's a defendant is never required never entitled to any type of good faith instruction. Now, the defendant argues that generally, if you have a defense, then you're entitled to an instruction on it. But good faith is simply a negation of the intent element. It's the state's burden to prove criminal intent, and the default is innocence, that a person is acting legitimately and lawfully. And that's all he was arguing here. He was arguing.
Counsel, may I just ask you the question about that point? If that's true, then when would someone ever be entitled to the good faith instruction? I mean, it seems to me that you're saying, is this what you're saying? That even if a defendant puts forth evidence or asserts a defense, and there is an instruction that supports that defense, that they wouldn't be entitled to it in the context of good faith? Is that what you're saying? Because it only relates to the intent element?
Yes, and we note that we acknowledge that the instruction he's requesting is an optional instruction now, but just preliminarily, we note that just because an instruction is in there, doesn't mean that it's binding law, and it's not an indication necessarily of when and whether it's necessary. And yes, we believe that good faith is simply arguing that the state has not met its burden of proving criminal intent, and specifically here, no juror would need to be told, especially considering counsel's argument that he put forth, that he was acting unlawfully or criminally when he was evidently allegedly trying to start a business.
So then in your mind, would a trial judge ever be required to grant a request for that instruction?
No. Now, in effective assistance of counsel context, I think if this court were to hold that that instruction isn't a defendant is never entitled to that instruction, that doesn't necessarily mean that there would be no effective assistance of counsel. Say if a lawyer got up and just didn't talk about the elements that were discussed in jury instructions. Well, in that case, there wouldn't be an effective assistance of counsel claim for not being given an instruction. It would just be a claim for his lawyer not doing a terrible job during closing argument. But as to the claim about the jury instruction, no, we believe that generally that is not that a defendant in a grand theft case is not entitled to any type of good faith instruction, and especially considering that the instructions may explain that there's got to be a specific intent to deprive. There's got to be unlawfully obtaining. Excuse me. And in addition to that, the instruction, standard instruction lays out, which we're given here, lays out different types of unlawfully obtaining, including fraud, false pretense, deception. And here the state, to the extent it wasn't clear which one of those it was, the state here argued that the defendant had a fraudulent intent, and the trial lawyer for the defendant got up and argued specifically as to the word unlawfully, and said that the state did not prove that his client acted unlawfully. And under Rosano's reasoning, we think that the instruction coupled with the lawyer's argument is sufficient.
But what are we to do with that? If we're of the mind that what counsel says, right, isn't the evidence, isn't necessarily the law, and that instead the trial court is going to instruct the jury as to what the law is, and an attorney just gets up and then says whether or not something is unlawful, and then that's not defined by the instructions, what are we to make of that? Because do you agree with Mr. Pinnell's side that he has asserted that the instructions don't define the word unlawful for the jury, correct?
Yes, that's true, that they don't define unlawful.
So then it's sufficient in your mind for an attorney to just get up and tell the jury what would be lawful and what would be unlawful?
Yes, and as I was explaining, the jury instruction just doesn't say unlawful. It further defines unlawfully obtaining or using or endeavoring to obtain with different types of conduct, including things that are explicitly criminal, such as fraud, false pretense, deception. And as I mentioned, that's a separate issue from whether, after the law has been sufficiently stated in the jury instruction, whether the defendant's lawyer has done a competent job as to arguing his client's case. And I'll go a little bit into why, at the very least, in addition to that, at the very least, he is not entitled to or why the cases he cites does not apply here. Those cases all go to a defendant arguing that he had made a mistake as to some piece of information. Because of that, he thought he could take the property that he took. Here it's different. He does not argue that he made a mistake. He's arguing that simply he acted lawfully, that he was engaged in fair dealing with the victims, with the women, to ask for money to start a business. And so those cases, at the very least, those cases don't apply. And for that reason, he's not entitled to the instruction. I'll move on to the prejudice point, unless your honors have more questions about what I was discussing. On prejudice, we win there because an additional jury instruction would not have made a difference to the result here. Because a rational juror already knows that it's not unlawful, as I mentioned, to ask for money to start a business. And the counsel argued that as to the unlawful element, and the jury could either take it or leave it. It was a simple theory. The state never said that defense was legally unavailable. The state countered with its own evidence of unlawfulness, and the jury could simply take it or leave it. And they just didn't buy it because it was obvious that all of the minimal efforts were just minimal efforts to keep up a front that he was starting a business so that he could continue to scam his victims. So the additional instruction would not have made a difference to the jury's calculus. Unless your honors have any further questions, I'm happy to stand by what we said in our briefs and arguments and ask for reversal on claim 3 and affirmance on claims 4 and 7.
Anyone opposed? Okay, counsel, you'll have plenty of time for rebuttal if you want, if you need to use it.
Please the court. My name is William Pennell and I represent Scott Campbell, the appellee in this case. Please reserve 4 minutes of my time for rebuttal on the cross-appeal issues.
Okay.
This court should affirm the decision of the trial judge to grant post-conviction relief. There's well-established case law indicating that a defendant who introduces any evidence of good faith is entitled to an instruction on good faith defense. And that goes all the way back to 1981.
Counsel, if we could just kind of jump right in.
Sure.
Let's just say for purpose of argument, we concede you're right. And maybe the state's wrong and that you were entitled to a good faith instruction under the way you've presented it under these facts. I think there's definitely arguments both ways. I've looked at the case law. But let's just, I wanted to jump past that and ask you layer 2, which in Strickland for an ineffective assistance of counsel claim, you would agree that you'd have to prove some form of prejudice. In essence, that if the instruction wasn't given, that it affected the outcome of the case, correct?
Sure.
So you address that in pages 27 to 28 of your answer brief. And you have a section titled Campbell was prejudiced by the trial counsel's failure to request that instruction. You cite some cases, and I want to walk you through those cases that you cited. One of the cases is Nichols versus State. Another case is Croft versus State. Those are 2 that you discuss at length. But in both of those cases, Strickland was not discussed, correct?
Sure.
All right. So really, I kind of moved on from those because I'm trying to look for cases where Strickland was discussed and the prejudice standard and which ones hit that. And then you did discuss there were 4 cases that you cited in that section: Hardman, Capiro, Alversano, and Owens. And you've made the statement in your brief that without a specific instruction on good faith, the jury could not sufficiently evaluate, and this is page, I think, 29 of your brief, 28 to 21. The jury could not evaluate Campbell's sole defense. As a result, it is beyond dispute that he was prejudiced by the absence of the instruction. This conclusion is fully supported by the aforementioned decisions of Hardman, Capiro, Alversano, and Owens. These cases all hold that a defendant is prejudiced by the omission of a good faith instruction because it deprives the defendant of his sole defense. So kind of walking through those cases because those cases are more kind of the ineffective assistance of counsel claim. Owens, did the Owens case from the 50s say, did that ever discuss Strickland? My read of Owens is it never actually touched Strickland.
Well, it certainly doesn't, the Strickland decision is not cited within the opinion. I think they essentially apply the analysis that comes from Strickland that a lawyer, if there's evidence of a defense, the lawyer has an obligation to request an instruction on that defense, and that he's prejudiced because this is the central issue in the case. And they support that conclusion by pointing to the question from the jury that's asked about the good faith defense. So I would agree with the court that Strickland is not mentioned, but I think they're applying the same analysis that a court applying Strickland would.
So my challenge with the Owens court, the Owens decision and the trial court's reliance on it is, because Strickland didn't appear to be directly raised, it seemed that the trial court just said, can you use a good faith defense in a situation like this, where it's a third party's property? And the court said, yes, you can. And then there was kind of crickets after that. There was never really discussion as to whether that instruction would or would not have prejudiced the outcome of the trial. So I to hang my hat on a case like Owens, I have a difficult time doing that because I like to look for cases where I know for sure an argument was made and addressed by the trial court or by the appellate court before I just, and I know you do, counsel, as well, before you just pull out a holding and say, hey, this holding is applicable, even though we don't see that the court ever actually wrestled with the idea of prejudice. But that being said, you do cite cases, you cite 3 additional cases that I think do discuss the second prong of Strickland. Those are the ones I kind of want to narrow in. That's Hardman, Capiro, and Aversano. And so looking at the Hardman case, and I'm going to kind of walk you through all 3 of these, and I want to give you a chance to speak to these. But in Hardman, the appellate court, in reviewing the lack of the good faith instruction, found that the good faith was the main defense. And this is a quote that I've pulled from it, that the defendant's entire defense was that he thought he had received loans. I'm skipping a little forward here. That failure essentially deprived him of his primary defense. And in Capiro, same thing. Capiro court held that the good faith defense was, and this is the quote from Capiro, here Capiro's entire defense at trial was that he thought he was allowed to spend the funds in large part because he and his wife signed the promissory note. Court goes on to say, we further hold Capiro was prejudiced by the virtue of the fact the jury was not presented with an instruction on the law applicable to his only defense. That's Capiro. Aversano, same thing. The court, in analyzing the good faith instruction, the lack of it, quoting the Aversano decision, thus the defendant's only defense was that she had a good faith belief based on the advice of counsel she had a right to act as she did. So my question to you is it your position here that good faith was the only defense that Mr. Campbell had in this case?
100%.
Okay,
I think that's unrefuted.
So how would you then, so to me, and maybe we're, make sure we're on the same page. The good faith defense at its core historically is this idea that, I thought that was my cow and I took it thinking it was my cow, but in fact, it was not my cow, it was my neighbor's cow. This is going back to the, farm days. A lot of the cases involved animals. And as we move forward, it's gone from cows to scrap metal to, water contaminated petroleum or petroleum contaminated water. And then I would concede it's extended into contract rights and money. But in all of those situations, there was this mistaken belief that somehow someone was entitled to certain property. Your case, in reading the closing arguments of the state, it appears to center on the state's closing argument was this, jury, ladies and gentlemen of the jury, this is about perception. This is about, Mr. Campbell creating these false perceptions that he had this massive business enterprise, that he had multiple $300,000 donors in his business enterprise. And these were false statements that were made in order to get people to donate their money. Now, if someone's making a false statement, in my opinion, if you're saying you made a false statement to me when you sold me that car or sold me that house or sold me that investment, isn't a defense to falsity truth? It's true. No, it's not false. It's true. Isn't that a defense? If somebody's saying that you're making a false statement when you're selling a car, this car is it's an original antique. No, it's not. No, I can prove it. It really wasn't. That's its truth.
That could be a defense, but in this case, the defense is he took the investor's money with the intent to invest all that money in his business, build his business, and pay the investors back. And
that's one slice of it. But when he was presenting this business opportunity to all of these women, he was making these representations to them that he had multiple $300,000 donors, which proved to be untrue. He's making representations to them saying, a typical investment in my business, my minimum investment, and he'd made this multiple times. And I'm not going to bore you with it, but I printed them all up, throughout the trial transcript, at least 5-6 times, half a dozen times, hey, my minimum investment here, ma'am, is $100,000. But in your case, because I like you, I'm going to make an exception. That was a lie. You can't keep saying that 6 times over, and
Well,
eventually, probably by the second or third time, it's a lie.
I don't
These
think
are-
what, I don't think what you're saying is incorrect, but what I think that's relevant to is the jury gets to hear those facts and then gets to good faith and decide instruction and decides whether he was actually acting in good faith. And
But
that's
counsel-
evidence, that's evidence he was not acting in good faith.
But he could
And
have.
his 5 witnesses and the 11 alleged victims, a lot of their testimony establishes evidence of good faith. So I think it's a jury question, and the jury wasn't given the tools they needed here to answer the central question: was he acting in good faith? I would agree that there's evidence on both sides, that there's evidence he was not acting in good faith, and there was evidence that he was acting in good faith. Judge Morgan said that when he denied the JOA, he said the evidence is consistent with 2 conclusions. This is a judge that sat through the trial, heard all the evidence, all the testimony in person, was able to hear the witnesses in person, observe their demeanor, and certainly a well-respected, experienced judge at the time. And he said the evidence is consistent with 2 different views. One, that he was making an earnest, good faith effort to build a business and pay back his investors, or 2, this was all up front so he could use the money.
Counsel,
So
why wouldn't that, if we just freeze frame, why isn't that taken care of by the instruction regarding obtains or uses, and specifically subpart C, where, and I'm in your answer brief now on page 18, if that helps you with your notes,
Sure.
but am I correct that this was read? These are the instructions that were read to the jury, and it states obtains or uses means any manner of, and then jump to subpart C, obtaining property by fraud, willful misrepresentation of a future act or false promise. If we just freeze frame for what you're telling us with regard to his intent and whether the jury had an opportunity to consider whether he's doing this in good faith or whether he is indeed a fraudster, why doesn't subpart C take care of that? I mean, wouldn't the jury necessarily have to pause there and say, and consider, is this a willful misrepresentation, or is it a false promise? Or did this guy really believe this was a legit business plan? Why isn't it covered?
I think if subsection C was the only subsection that was read to the jury, you'd be correct. But we have all these other subsections that don't require fraudulent intent, and we don't know what the jury relied upon. So as instructed, they were not required to find fraudulent intent because they could have used subsection A, B, or D, or E. So we don't know that they used that subsection. And the good faith would told them, the good faith instruction tells them, they're told it has to be unlawful, and the good faith section tells them what's lawful. It's similar to when the introduction to homicide, where it says first degree murder, second degree murder, manslaughter are all unlawful unless they're justified or excusable. And then the judge tells them what justifiable or excusable is. Here, it's gotta be unlawful, but it's lawful if you acted in good faith. That's the missing part. And again, if you just had subsection C, I think you would have a very good point. But we don't know what the jury relied on. And if the state would have narrowed it down to that, I think it would have been different. I think it would be different if the instruction said, Mr. Campbell obtained the property with the intent to steal. That's the part that's missing, the intent to steal.
Was that the focus of the closing argument by the state?
It was the focus of closing argument for both parties, but the reason that doesn't, the case law is clear that failing to give an instruction, that closing argument isn't a substitute for instructions on the law. And that's the Nichols case, which it says allowing defense counsel to argue a theory of defense to the jury while also refusing to instruct the jury on that defense does not solve the problem of improper instructions, because the defense argument would have carried more weight had the jury known that the law allowed it to accept such defense. Then in Cliff Berry, it says, It's one thing to inform the jury of the state's obligation to prove each element of its case, but quite another to inform the jury that certain matters, if established, constitute a defense to the crime charged. And the Cliff Berry decision says, and this is back in 2012, prior to the trial in this case, it is already settled that the standard instruction on the element of intent is insufficient to adequately cover the effect of a defendant's claim of good faith. It is one thing to inform the jury of the state's obligation to prove each element of its case, but quite another to inform the jury that certain matters, if established, constitute a defense to the crime charged. So they're saying that the standard, they're saying it's well established that the standard instruction is not sufficient without the good faith instruction.
And there was a standard instruction in place at the time of this trial, or there was not,
There
and
was
they would have crafted that wholesale out of whatever case law they deem applicable.
Correct, there was not. It was, the standard instruction was created in 2016 based on the Cliff Berry case after our client's trial.
Okay,
And it's still a standard instruction today. The Supreme Court, and I know that there's the hedge language at the end of all those opinions, but the Supreme Court proposed and asked for comments on a standard instruction on good faith and enacted it. And no court has said that that's improper. And we, at the time of trial, which is the most important, there was a multitude of cases that says if you have any evidence of good faith that you're entitled to that instruction. There's a multitude of cases prior to trial that says it's ineffective not to ask for that.
but
Trial
it's
counsel,
only ineffective, right? If we get through, because to me, there are two different scenarios here. And I think it kind of bears on Judge Young's order in this as well. But we can look at it at the time of trial. And at that moment, what would a defendant be entitled to, right? But we're in a much different position once we're on post-conviction relief and we have the two-prong test set forth in Strickland. So it seemed to me upon reading Judge Young's order that perhaps I don't see, do you see in that order prejudice really fleshed out? It looks like there's a concentration sort of on the duty element, so to speak, where is this defendant entitled to this instruction? And I'm wondering where that second piece is. Where's that analysis of prejudice?
I don't know that he does a detailed analysis of prejudice. It'd be disingenuous for me to argue that Judge Young, it's obvious Judge Young begrudgingly granted this motion. Okay, so he said he was bound by Owens. We think that Owens applies prejudice. I disagree with Judge Smith about it not applying Strickland. I don't think we can presume that. We don't have the motion for post-conviction relief in front of us. We know it was a Rule 3850 motion alleging ineffective assistance of counsel. It would seem bizarre to me that the trial judge didn't apply Strickland, and that the appellate court didn't apply Strickland. It would be better if it was in the opinion, but I don't think we can presume they did not. I mean, the standard for ineffective assistance of counsel has been Strickland for 60 years. So I would expect that the trial judge in Owens and the three judges on the appellate panel certainly applied the correct law, and I don't think we can presume they did not by its absence. And I think the Capiro case is the case that's closest on point.
So you're well into your reserve rebuttal time, so.
Okay. I think the Capiro case is the closest case on point, and they find deficient performance and prejudice, despite the fact that the good faith defense is discussed in the opening and closing arguments. And they say that doesn't matter, and they still find prejudice. And that the Nichols case and the Cliff Berry case say that. It's not the same thing. There's a self-defense case in my brief where a judge here in Orange County said you can argue non-deadly force, but we're not going to give the instruction. And the 50C reversed that and said that's not appropriate. That's what happened. They got to argue it, but the jury wasn't given the tools to apply it. And it's well established, as noted in Cliff Berry.
And
that
our
the-
court just issued one of those on the self-defense, but that's a whole different standard. That's going down a whole different path.
It's the same concept, though. It's the same concept. If there's evidence, any evidence of self-defense, you get a self-defense instruction. If there's any evidence of good faith, you get a good faith instruction. The law.
But how can
according
you
to-
say there's, I mean, he's representing that he has Flava Flav and Ludacris as clients. There was no showing that he had a good faith reason to believe that they really were his clients when
The
weren't.
good faith argument is was he trying to build his business, and did he intend when he took the money, when he obtained the money, did he intend to repay it to his investors? And the misrepresentations are evidence the jury can consider when determining whether it's good faith. The court doesn't get to decide, well, you know, the court doesn't get to weigh the evidence when it's deciding whether to give an instruction. And so we'd ask the court to follow Capiro, and all the cases cited in our brief, especially the Cliff Berry case, which says it's well established that the standard instruction without the good faith instruction is not sufficient. And we'd ask for you to affirm.
Give you a couple minutes in rebuttal. We've got about 11 minutes, so.
All right, I probably won't use all that time.
Counsel, can I jump in? Is there any scenario in your mind where a defendant would be entitled to the good faith instruction in a case such as this? Is there any scenario?
No, because the jury instruction, including the part that you specifically pointed out, makes it abundantly clear what kind of criminal intent is required for this type of crime. And on top of that here, the state at 1356 to around 1359, 1357, the states, my friend said that the state didn't make clear exactly what kind of intent he was, or what kind of intent he was. The state was accusing the defendant of, but the state argued that it was specifically a fraudulent intent. So when you have the instruction and in addition, the argument that makes it clear what kind of intent is being discussed. I'd add that there should not be undue weight given to the Florida Supreme Court enacting this optional instruction. The court has made it clear that just because it's an instruction, as I mentioned, that doesn't mean it's a correct statement of the law. And
Counsel, do you agree with Mr. Pennell's assertion that this was his client's sole defense? This good faith defense was the sole defense raised at trial? Because there does seem to be some dispute with regard to whether the state was making as much of a concession apparently as the trial court thought. I'm not sure it's as great of a concession, but there is nevertheless in here in the response and opposition to the 3850. There's this concession that good faith was part of the defense. Do you agree with Mr. Pennell that that was the sole defense presented at trial?
I think if we look in context of what the state was saying at that time, the state never conceded that, the state made clear that these cases, as Judge Smith alluded to, all these cases don't apply to the defendant, but he did not argue that type of good faith at any point. At that, where Your Honor cited.
The defendant argued a different type of good faith. Is that what you're saying?
That's how the state put it. We'd say that his defense is a defense of, say, fair dealing, making honest effort. And as to that, we'd say that that's not a defense that requires an instruction. He's just saying that his client did not, or the state has not proven an unlawful intent. And in fact, at 1407, 1408, the defendant, this was during his closing, he said, he told the jury that what this is about is the word unlawfully, and then he explains that the state has not proven that my client acted unlawfully, and then he goes into his interpretation of the evidence of the facts to argue that his client was trying to start a business of good faith. That his client was simply acting innocently.
So you're saying it's different good faith than what Judge Smith was alluding to. It looks just like my cow.
Exactly.
He's going more to the elements of what he was seeing in this, that he was representing to all of these women. And there's nothing there from the state's perspective that relates to a misunderstanding as to what an item was versus what he was saying they were investing in.
Right. At no point did the defendant argue that something like I made a mistake. I didn't know something about like what was in his mind. He was saying like everything I did was on purpose, but it's just that I was honestly trying to start a business. And of course, the state came back with this evidence with its interpretation of the facts to explain that. That in fact, all of this was just like a minimal effort to keep up front, and there was also affirmative misrepresentations and deception to show that he was not acting honestly. So I have done, and as I mentioned, we asked the court to reverse on claim 3 and affirm on claims 4 and 7. Thank you.
Counsel, you have anything further?
I would just, may please the court, I would just add that if you look at subsection A of the instruction, it says, quote, taking or exercising control over property. So that's obtains or uses. So the jury could have relied on that without finding fraudulent intent and could have found Mr. Campbell guilty. Without the good faith instruction, they're not told what unlawful obtaining is.
But Mr. Pennell, if that's correct, wouldn't we sort of have to disregard the arguments that were made? I mean, if we presume that the arguments that are made at trial are taking the jury to down a certain path, telling them the story of the case, here's the evidence, here's what happened, here's the applicable law, wouldn't it be sort of out of the blue in this context to ask them to focus on the taking or exercising control rather than the willful misrepresentation or false promise? I mean, or is there an abundance of argument in this record where the attorneys are harping on taking or exercising control?
Well, there's an argument in closing by the state that we raised in our cross appeal where they say it doesn't matter whether it's a gift or a loan, it's a matter simply that he obtained it. And so that tracks subsection A. And the cases I think are legion that says that absence of instruction can't be cured by argument. The jury is instructed on the law, as you asked co-counsel, my opposing counsel in the beginning. The jury is instructed on the law. They're told the arguments of counsel are not the law. So to say that the arguments of counsel clear this up, I just think is mistaken and incorrect. And Capiro says that they discussed this during closing. Not enough. The self-defense case I cite in my brief says just because the defendant got to argue non-deadly force doesn't work if you weren't given the instruction. They weren't given the tools they needed to know what unlawfully was. And there's no good reason for the trial lawyer not to ask this. He didn't give a good reason, and he wasn't even aware of the case law. So he was both deficient, and this was the sole defense. The states conceded it. They don't.
Where are they conceding it? Are you talking about the response and opposition?
I'm talking about that, and I'm talking about in their brief. I don't think they've ever said in their brief that they disagree. So number one, they conceded it below in their response. Judge Young asked them about that at the hearing. I don't think they responded to the contrary. So I don't think there's any argument below that supports them preserving this idea that they didn't concede that. And I don't read the brief to say that. So I don't know where there's an argument that it's not the sole defense. So I think that is not something the court can consider. I think that's a fact of the case at this point. It's been conceded by the state.
Judge Smith has a question that we will.
So counsel, yeah, just going back to my initial question, and my challenge with cases like Cliffberry, you can bring in a lot of cases that are direct appeals. And I would agree it's a different standard if you had asked for a good faith instruction at trial. We are under Strickland, so we've got to hit the rung of prejudice. And I do believe the state very clearly rang the bell of that they believe that there was no prejudice. And I'm not going to, for the interest of time, that the evidence was overwhelming of effectively the fraud that had occurred here. Going through the record, going through the closing arguments of the state, they raised issues that some of which I've already mentioned, that your client had made these false statements that he had multiple $300,000 donors. He made false statements that the minimum investment was $100,000, but because I like you, and this is just 6-7 times over, because I like you, I'll let you in for 5,000 or 7,000 or 20,000. False. These are just false statements. There is no good faith is not a defense to a false statement. Truth is defense to false statement. Good faith is, I believe that, that was my property, but truth is the defense to falsity. But it's not just that. It said he claimed that he had a payroll of $3,500
Judge,
and he had no employees.
Judge, he's not charged with making false statements. He's charged with grand theft and it's a complete offense.
Well,
And-
Counsel, I disagree with you there. He's charged with theft and one of the elements of theft is taking property under false pretenses, which is what the state argued, taking property under fraud, which is what the
And the
state.
jury's free
that was
to
in
come,
theory.
jury's free to come to that conclusion with the proper instructions. It's a jury question.
Well,
And they weren't given. the
Counsel,
tools they needed.
let me finish where I'm going with this. So then your counsel tells people, that he's got these guys like Noah Bombay, projecting him to make $500,000, no 1 million, no 3 million, no 50 million. He's just pulling these facts out of the air that are clearly demonstrably false. I need money right away. And he told women that over and over, there's this big deal that I've got going on. There was no evidence of any big deal. So what we have, and this is the thing, counsel, I have not touched your good faith point in everything that I've said. Your good faith point is, just give this guy enough time. He's going to make money and he's going to succeed out there. Everything that I've mentioned to you about the false statements about the investment, prior investors, the minimum investment amounts, deals that need to be turned right away, a payroll of $3,500 when in fact he had no staff. I have a bodyguard when he has no bodyguard. All of these statements that he made to falsely induce women to give this money. None of those were refuted on the record. The state introduced their evidence. The defense gave no defense to any of these false statements. And we as an appellate court have to find that had the good faith instruction been given, that there would have been a different outcome. I can't see that there's a different outcome. Tell me how a good faith instruction combats facts and falsities that were never confronted factually by your client at trial. How would a good faith instruction changed anything?
Well, let's make sure we're using the right standard. Because you don't have to show a definite outcome. You have to show a reasonable probability of an outcome being.
Tell me that.
That's less than preponderance.
I
So-
don't think I used the word definite. I just said a different outcome.
Okay,
You put the word definite. in
so,
there. I never
so,
said
I mean, he was deprived of his sole defense. The sole defense he argued is not covered by the instructions. Each case that finds ineffective assistance of counsel, including the Capero case, says if you don't get the instruction, it's not a reliable trial. This is about reliability. You've laid out a very good argument for the state and why Mr. Campbell's guilty. The jury may find him guilty again if there's a retrial, but he wasn't given a fair trial where the jury got the tools they needed to analyze his defense. I don't think it's a job of this court to weigh the evidence. I cite the decision of Romero that says even when there's ample evidence, there can still be ineffective assistance. So I think we're going down the wrong road where we start talking about there's unrefuted allegations. And I disagree with Your Honor when you say that he's charged with making false statements. He's charged with grand theft, and good faith is a complete defense to grand theft. And he wasn't given that defense. The jury wasn't given the opportunity to rule on that defense. It's plain and simple. The remedy here, if this guy's so bad and he's so guilty, is for a retrial with the appropriate instructions.
Well, counsel, let me just make it as plain as I possibly can. So he makes multiple statements to these women that the minimum investment amount is $100,000 multiple times. That's a lie. How does a good faith instruction have anything to do with a bald-faced lie like that?
Because there's 11 alleged victims that say that he made no promises to him, and 6 witnesses for the defense that talk about all the good faith efforts he was making to build his business and to make money and to develop his artists. So there's substantial evidence both from the alleged victim's testimony and this defense testimony, including a record and an executive producer, and a federal law enforcement officer that talk about all the efforts that Mr. Campbell was making to build this business.
But is there any evidence that he had a minimum $100,000 investment?
But that's not the question for the court. I
That's
think
what he represented to
but-
these
but-
women.
but we're not
He could
not
have, counsel,
not
he
here
could
to-
have presented a defense of truth.
here today to determine whether he's guilty or innocent. We're here today to determine whether he got a fair trial and effective representation. I believe when we focus on that type of question, we're just reweighing the evidence and deciding, you would have found him guilty.
But when it comes to the prejudice prong, when there's statements that were made, such as the one that jumped out at me is Ludacris and Flavor Flav and whoever he's saying that these are clients, which is making people go, oh, well, these are people I'm working with. I've heard them, I know them. The jury is considering that, and we're looking at it under the prejudice prong. Those are just flat out falsities. So where's the good faith? How is there a good faith element to that misrepresentation?
Well,
Is it because
there's a good
he
faith-
met them once and has a picture with them so he can say?
I don't know that we need to go one by one and say, well, there was three lies, so there was no prejudice. I think if all these investors said he promised a return in 2 years and guaranteed it, and we didn't have the 6 defense witnesses saying that he was making honest, good faith efforts to build his business, then I would agree there'd be no prejudice. But we have 6 defense witnesses, and this is outlined in my brief in detail about all the evidence of good faith. And if you look at that, the evidence is not overwhelming. And we don't have to guess about that. Judge Morgan said the evidence is consistent with 2 possibilities. One being that he was making an earnest, good faith effort to build his business and repay his investors. He was there. He didn't say JOA denied, this is ridiculous. He didn't say JOA denied, this is overwhelming evidence. He said it's a close case, but I think there's evidence of guilt. We're to let the jury decide.
Okay.
Thank you.
We're going to be in recess until 11 o'clock for the next case where Chief Judge Traver will be presiding. Recess.
All right.
We are back on the record. This is case number 23-1084. Casey Ascar versus Susan Abo et al. I'm Dan Traber. We switch dealers. I'm joined on this panel by Judge Brownlee and Judge Smith, who presided which case this morning. Mr. Shaneen, 5 minutes is the default on rebuttal unless you'd like more or less.
I would actually like to shift it up, given the number of parties that.
Okay.
Discretion.
Absolutely. Gentlemen, before we get started, have you discussed how you're going to divide your time?
Yes, Mayor Fraser, have discussed it, probably taking 12.5 minutes. Serious. And then the other council can take, they have each, hanging out.
So, counsel, what order do you want to do this in? Yeah. Mr. Just tell me your last name again. Okay, right on. Sir.
Your Honor, Damian Taylor on behalf of the Appellee legal scholar. I will plan on 2.5 minutes. If Mr. Jackson cedes his time to me, I would like the discretion to either use it or cede it to Mr. Cotcamp or back to Mr. Fraser for rebuttal.
All right, so Mr. Cotcamp, then that would leave you strong suit with 2.5 minutes. All right, so what I'm going to try to do with that caveat is that I'll watch your time and I'll let you know when you're coming up on your break, and we'll just kind of reconfigure it as it goes. Okay. Any questions about how we're going to do this? Awesome. Mr. Shaneen, at your convenience, sir.
Thank you, Johnson. May it please the court. My name is Nick Shaneen, and I represent Casey Ascar, appellant, in this very important case involving defamation, fundamental rules of civil procedure, and a novel issue before this court that has been addressed by 2 different district courts of appeal that are in direct conflict with each other. That conflict pits 2 schools of statutory construction against each other. The textualism method of statutory construction versus the purpose of this method of statutory construction. Casey Ascar urges this court to find that the reasoning of the 3rd DCA in its Lamb versus Univision decision is the correct statutory interpretation to be given to this issue, and in doing so, reverse the lower court that relied upon the 2nd District's Gundel decision that relied on a purposistic methodology to arrive at a result that is not found in the text and in fact is at odds with our fundamental rules of civil procedure for a basic plea.
Mr. Shaneen, may I just interrupt you and sort of jump right into an issue that's bothering me from a procedural standpoint? We have this important burden shifting argument and the text of the statute, and I'm aware of the different lines of authority that you're referencing. However, even if we agree with Lamb and that that burden shifting under the statutory language only applies to summary judgment motions, not to motions to dismiss, even if we were to agree with that, if we found that the complaint should nonetheless still be dismissed, because say one example would be whether it's a shotgun pleading that has been argued by the opposing side. If that's true, and if then the trial judge could have granted leave to amend, my struggle, unless you can show me otherwise, is in the initial brief, there's no argument about leave to amend. How could we grant you leave to amend?
The initial brief, and I, upon reviewing the briefs written by my predecessor counsel, I recognize that
it would have been far better had he set out a specific argument heading that indicated that. Of course, that argument does occur in the reply brief robust, or the multiple reply briefs that you will. Here's why this court can still reach that issue. My first analogy is it's a lesser included, to use parlance from the criminal procedure, that we are talking about a dismissal with prejudice. Inherent within a reversal of dismissal with prejudice is that the alternatives exist. It's not necessary to spell out those alternatives as insular legal issues because it's built into the core legal issue of, was a dismissal with prejudice legal error, yes or no? Once you check that box, yes, then this court can fashion its remedy appropriately. I would
But is
also,
that true, Mr. Shanine? I mean, what if we disagreed about the shotgun and the procedural deficiencies or the pleading deficiencies of the complaint? Say that we disagreed with that and we really thought this was a improper burden, that the trial court was incorrect in following the line of authority out of the second DCA and instead should have followed Lamb and perhaps the text of the statute, okay? Say we think that's the only problem. Wouldn't we just reverse and there's no amendment necessary?
well, certainly the court could do that. And that's kind of what I'm saying, Your Honor, that this court has, of course, the ability to fashion the remedy as this court sees fit based upon the facts of the case.
But leave to amend separate than that. I mean, if we just reverse and we say, go forward on these pleadings, that's different than that was indeed a bad pleading. You need to try again.
And I see Your Honor's point. What I would suggest to that is that the standard that we are here for is an appeal of final order, and therefore it's not akin to a cert petition where all this court has is the ability to quash, and then if it's not self-evident what quashing means, that's where problems exist. Of course, the language within the order itself generally suggests that a trial court one should do on cert. One important distinguishing factor I would also raise to the court is this: the appeal is of the final order as phrased. We have our complaints about how that final order came to be. But what we do not complain about is that the final order contained the actual finding of the court below that. But for the Lamb versus Gundel issue, I would dismiss without prejudice. Yes, I would dismiss without prejudice. That's exactly from the trial court's order itself. So if a reversal of this court says to the trial court, well, now you have to do what you were going to do, but for this issue, the trial court told us.
How does that factor in though? So it seems that the parties agree, you'll correct me if I'm wrong, that what y'all have been calling the Texas hoax
Yes.
does not implicate the anti-SLAPP statute.
That is, in fact, as the judge indicated in that order, yes.
So then help me reconcile then if we're not dealing with Gundel versus Lamb in this district split. It seems to me that the reason that the Texas hoax counts were dismissed was because it was a shotgun pleading. So how do I say dismissal with, if I follow your argument, how do I say dismissal with prejudice as it relates to the FEC and the Harvard statements, and dismissal without prejudice as it relates to the Texas hoax when what we've been presented with is a final order?
I would disagree with this court on the nuance of the Texas hoax. It is correct that the lower court order and pretty much the parties by consensus have said the FEC statements and the Harvard statements, those are subject to this SLAPP versus anti-SLAPP analysis. The Texas hoax is not, but it is actually an issue of law and not the shotgun pleading issue that is the core of the court's ruling on Texas hoax. But essentially, the lower court didn't mind. And what I mean by that is the lower court said, you cannot, as a matter of law, say that a statement about another candidate, in this case, Mr. Donald, is defamation as to you, Mr. Ascar. It doesn't make sense. He called it tedious. It wasn't, there was the original portion of it that collectively referred to all of them as shotgun in nature. And I would argue that that is not the case, that this is in fact not a shotgun pleading. That this is a pleading that meets the criteria of the rule of civil procedure 1.10b of plain and straightforward pleading. It is, if you're going to plead a conspiracy, you are going to have multiple defendants in particular counts, but the complaint actually attempts to not just say, okay, we're going to refer to every paragraph that preceded in each count. Instead, the council is, no, these paragraphs, those paragraphs, this paragraph. And by separating the FEC statements and the Harvard statements, the complaint again separates out Ms. Abo, the Venetis, those weren't involved with the FEC statements, but they were involved allegedly with the Harvard statements, which is why complaint, as much as people like to just, it's a shotgun, it really isn't, Your Honor. And that's going to be our core defense of it, is that you don't need to worry about the nuance, because it was that complaint.
Was that argued though in the initial brief? I just don't see a ton of focus. And I recognize you didn't write it. But I don't see that there's any real focus on the shotgun pleading aspect of it. And I guess we're not postured this way, but we should have a separate argument all day as to whether or not the trial court abused its discretion in saying like this is or isn't a shotgun complaint. I get that we're not doing that.
Right.
But I think what I'm struggling with a little bit is the fact that the initial brief is silent on it.
And it, even to that extent, it wasn't entirely silent. That in the statement of facts, it refers to the specific circumstance of the being done with prejudice, without prejudice. That was in there. It did not have a set aside individual issue. And I would say that if the trial court had not conceded that, but for Lamb versus Gundel as a dichotomous situation here, I would dismiss this without
But
prejudice.
I think that's a good point, right? So that's a fair point, that if that were in the brief, and this is the hang up for me, then the other side would have an opportunity to respond to that and say, judge, here's what I think about that argument. It's a due process concern for me if it's not set forth in there, thereby giving them the opportunity, notice and the opportunity to be heard on it. We're going to hear about it at oral argument, but perhaps for the first time.
And to that, I would respond that because the reversal sought was as to the order itself and not to other permutations that the judge didn't order, the initial counsel did not feel it necessary to carve that out as a unique and insular argument, but the other side, and they will get up here and argue about that, very much included in their briefs. Oh, wait, they didn't, it wasn't this nuanced preservation argument. It was the dismissal should be with prejudice was appropriate because, and they go on about the shotgun pleadings, they go on about the other things. But so to the extent that any, amorphous due process argument, what we're here, it's a moot point because they played on it.
But they don't know what you're going to say about it.
They would not until the reply brief said what it said about it, but they did know because it was raised in argument below, it was raised in motions for rehearing. If it was vetted, it simply wasn't discreetly analyzed.
But even in the reply brief, am I correct? It's only in, and I'm not trying to harp on this, I really want to make sure that I've got it all right. It's only in the conclusion of the reply brief. So even then, like the factors a trial judge would consider for leave to amend, prejudice, futility. I mean, that's not fleshed out.
Well, actually, I don't, while the analysis of what the remedy would be is contained in the conclusion initially in the reply.
I don't think that's true.
Okay,
And that probably sounded sharper than I
No,
intended.
no.
I mean, I really don't think that's right.
if I may, I'm just gonna get.
Let me
Sure.
keep you up here on something else and maybe you can address it. Maybe you can address it on your rebuttal.
That would be fine.
So it's an interesting argument on the motion to dismiss, an interesting transcript for me to read below, because the parties again seem to be agreeing that there are some things that are outside the scope of the four corners. There's some discussion about the fact that your client perhaps didn't technically graduate from Harvard Business School. There's some discussion about the fact that your client amended his FEC complaint. In light of the actual malice standard,
Sure.
in light of the challenges of proving defamation to which a defense is truth, what weight, if any, do we give those? The trial court didn't say, do you stipulate on this? But it also didn't seem like trial counsel was hopping up and saying, you know what, he did graduate from Harvard Business School. He didn't amend that FEC disclosure because he didn't have to. How do we as an appellate body
Sure.
weigh that out, if at all?
And the easiest answer would be Not at all, simply because our standards on the motion to dismiss are so crystal clear as, beyond need for citation, how it must be contained to either the four corners or, if you will, the eight corners, where you include the exhibits to the complaint. And in this case, it cannot meet that muster if we are containing ourselves to it. But to the extent that there was discussion, even within the four corners of the complaint, Mr. Ascar, it states about his Harvard education that it was a program and not a collegiate undergraduate or, program.
I mean, the exhibit says graduate.
It does. And so, and that would be a fair issue of fact for resolution later. Was this or was this not truthful? But that cannot be resolved, just like actual malice cannot be resolved, just like conspiracy cannot be resolved. These are not issues subject to a motion to dismiss.
You're
I
in
see
your
that
rebuttal.
I've reached my rebuttal. Thank you.
May I ask one question, Chief? Now think of your question, Brownlee. So, my question to you is, did Mr. Ascar argue to the trial court? I don't know that he had the benefit of Lamb. I can't reach into my brain and remember the exact dates, but did he argue that burden shifting does not apply in the context of a summary, in the context of the motion to dismiss, but only in the MSJ?
My understanding is yes. I know for certain it was raised in depth in the motion for hearing.
That's right. Okay.
So,
Thank you.
thank you. Thanks.
All right, let's see how this works. Mr. Frazier.
Good morning again, your honors. May it please the court, David Fraser, I represent the Appellees, Matthew, Hurley, Rachel, Hurley, Andrew Duskin, and Bigger Insights LLC. I think the principal issue before the court today is whether Florida's anti-SLAPP statute is a garden variety fee shifting statute, as a third district, I called it in Lamb, or if it's something more that requires a burden shifting approach, as a second district is said in Gundel, Baird, and Davis versus Michigan. The Appellee submitted something more. Before I get into why it's something more, I want to come back to Judge Brownling's question earlier. There is another, and again, why it's important it's briefed, because I would have known exactly what they were going to say. But this idea that that dismissal with prejudice, reversal of that requires leave to amend, I would disagree with that. There's also what the judge said he would do. He would dismiss it without prejudice. So this court could dismiss without prejudice. It's up to them if they want to file a new suit. It's not a res judicata. If it's dismissed without prejudice, the case just goes away. So I think they could, if the court was inclined to follow Lamb, the idea that amendment should have been given wasn't raised in brief, there would be a dismissal without prejudice. But coming into the text of the statute, our argument, I'd like to take credit for it, but we follow the argument in Gundel. We cited Gundel in our SLAPP, our motion to dismiss, and it's focused on the text of the statute that says that these lawsuits are to be prohibited and they're to be expeditiously resolved by the court. Once we raise the issue of the anti-SLAPP, the burden shifts to the defendant. I know the court has read those cases. And
but that line of authority you're relying on is solely out of the second district and doesn't have, am I correct? No other district agrees with the second on that.
Right. No other disagrees with second. And I would also state that no other district agrees with Lamb with respect to the burden shifting. There is a case out of the fourth that agrees with Lamb on a petition for cert, and that
There's a lot of cert authority out there. I know that's a hot button issue right now, but with regard to the burden shifting, if I just jump you right to it and I look at subpart 4, I mean, the legislature clearly talks about, and I grant you that there is this support in the text of the statute for resolving these issues, early on. But in subpart 4, it states a person or entity may move the court for an order dismissing an action or, right, it's in the disjunctive, granting final judgment in favor of that person or entity. So it has talked about both of those procedural mechanisms. And then the next sentence only talks about summary judgment. So the person or entity may file a motion for summary judgment together with supplemental affidavits, but no mention of a motion to dismiss.
right, and Gundel addressed that, when they said, well, look, we know what we have to do for summary judgment. What do we have to do on motions to dismiss? And that's where you have the Gundell line and Michiev, Davis versus Michiev about that
But
too.
why isn't that just putting into the statute something that is not there?
Well, because the court is required to, again, these lawsuits come in front of the court as they're prohibited slap suits, and they have to be expeditiously resolved. If the court says, let's follow, as the appellant is arguing, let's follow the ordinary rules of civil procedure, then we're not expeditiously resolving these disputes. If we drew an analogy to the immunity statute, stand your ground. The stand your ground statute was enacted in 2005, and since 2005, I think the first case was the Davis in 2010. The Supreme Court noted that the prosecution was arguing that they had to raise this via motion to dismiss. All facts and the information were taken as true, and the Supreme Court rejected that. Although that was nowhere in the statutory language of the immunity statute, it said in order to meet the statutory intent of the stand your ground, we have to do something a little bit differently. And we have to apply, give these people an ability to enforce this right. And the right in the immunity statute is to avoid the lawsuit altogether, not to be drugged through those proceedings. So it happens, I wouldn't say all the time, but it happens. We saw in a very similar immunity statute, which courts have analogized to, that we're going to follow a little bit different procedure.
I think that the standard, I understand what you're talking about with regard to the context of that statute. That's a pretty unique statute, though. I mean, what about, couldn't the same be true for a sovereign immunity case where, hey, that's immunity from suit and immunity from liability, and therefore it should I don't know if the language of the statute says this, but it stands to reason that this should be decided expeditiously, right? Because of that immunity. But if I'm deciding as the trial judge a motion to dismiss on a sovereign immunity issue, am I then looking at affidavits or whatever discovery has been marshaled and exercising some burden shifting component that's not in a statute?
I think it's a good question. I understand the question. I would fundamentally state that sovereign immunity, the people who obtain sovereign immunity are in much different situations than the people who are seeking slap protection. If they engage in political speech, you have individuals, and we also have the legislative intent, which is cited in numerous of these cases that says, look, you want a robust public dialogue on issues such as political speech. Here's political speech. This is the utmost of First Amendment protection.
Seems like, though, that when you have a statute that specifically cites different ways that you can expeditiously resolve it, the leap that you're making that I think is equivalent to what our colleagues in the second district did is that it's sound public policy to require proof, whether it's the pleading or the proof standard. And where I think I'm having some issues with it is that if a hypothetical defendant wanted to challenge assertions that implicated their First Amendment rights, then they have the ability to elevate it to the level of proof as opposed to just pleading where we're at right now. I mean, you agree with me, because I rambled to an end of my question. You'll agree with me that you can't just go and call your election opponent a pedophile. I mean, that's still defamation, right?
Right. And so your underlying question is, was there a jump? I don't think I would disagree there's a jump. I would state that there needs to be a mechanism for enforcing a dismissal right. And I would draw an analogy between the Baskin case, which was offered as supplemental authority. In the Baskin case, you have, and it actually started out as a pure bill of discovery. So you have all of these, you have one plaintiff and one defendant, and you have a little over 10 statements that were identified on a blog stating she forced signatures, she stole money, she stole property. So at that point in time, you have a specific defamatory allegation. If you look at in like the pedophile example, that's a pretty specific defamatory allegation. Here you have a very broad pleading that says all these people conspired to do these things, even, multiple cases, of course, that these pleadings were filed or similar pleadings. There you have to show some evidence supporting these allegations. You can't just make all these.
Go ahead, Chief.
I think what you're trying to say is that the burden, well, maybe I'm not following. If what you're trying to say is that the nature of the allegation shifts what the statute means as it relates to your proof requirements, that's tough.
That's not what I'm saying is that the detail of the allegation can show the court that this case can survive, and it's not just a mere anti-slap case. I mean, a slap suit. If you just sued a bunch of people saying these people defamed me, I think it's well within the court's ability to say, you need to provide more details for this. And so if we're at the motion to dismiss stage, you have to show actual malice for a public official. At least
They pled that, right? That's pled.
they played it in a conclusory fashion, saying that all these people, had actual malice. But and if we're going to expeditiously resolve these disputes and we state all you have to do is plead it, then a person, and it was a Misiev case, said you can avoid the purpose of the SLAPP statute by being intentionally vague. And then you could have a SLAPP statute that's intentionally vague. And
Is there some heightened requirement for pleading malice, like there would be fraud?
I don't know the answer to that. There's one counsel here that was handling that argument principally. I'm sure he'll pop up here in a second. I do know that you have to plead it with detail, and malice is
1.120 says you have to plead it generally. And it contrasts it to fraud, for example, which needs to be pled by specificity. And defer to your colleague if you'd like, but my question would be whether it's to you or to him. Does that mean that the SLAPP statute somehow, without precisely saying so, contravenes 1.120?
No, I would state that I don't think a well-pled allegation is not these people acted with malice. Malice is knowingly making a statement that's false or reckless disregard for truth, right? The complaint doesn't state that. It just says these people acted with malice. I don't think if we're going to give the statute becomes meaningless, the dismissal portion of the statute becomes meaningless if the person can just say they acted with malice, I've been damaged. Then what mechanism? I can't think of a mechanism other than you move on the SLAPP statute to state, okay, how do you know these things? How do you know all these people engaged in it? And it's another appeal in front of this court, the Byron Donalds appeal. It was alleged that Byron Donalds was the one behind this text message framing Casey Ascar, the Texas hoax. And it's also alleged that these people are the ones that did it. So I think the court has to have some ability early on to look at this and say, this is a pleading that's not well-founded in fact.
And it's not, okay, so let's talk about the pleading then. I've heard you say shotgun pleading. Mr. Shanine has argued, well, this is a conspiracy. So you necessarily, unlike a normal case where you might separate counts that pertain to various defendants or various different acts or violations of statutes. So here, if it's a conspiracy claim and we're naturally lumping them together, is it a true shotgun pleading? And also, could you tell me any other pleading deficiencies that you think exist in the amended complaint?
I think it's a shotgun pleading from the standpoint that, all these people conspire to do all these things, and we don't have the dates of any of these acts or who actually took acts in furtherance or those types of things. But just to broadly state that these people committed conspiracies, I think I don't know how we know this or when these conspiracies took place or acts in furtherance of. The pleading deficiencies, I would just go back to would be any conclusory statement there. That they made the statement to the FEC with the intention of causing them harm. I think that's a conclusory statement that doesn't have required.
Well, I mean, functionally, how could a plaintiff, if we're going to get into intent, to me, that's a huge factual issue, right? That would be put forth before a jury, I would think. Wouldn't it be very difficult to require plaintiffs to start establishing and now proving through this burden shifting framework, there was malicious intent?
I don't think they have to prove it. They have to make a showing to the court that the case could survive. Just like in Baskin, when Judge Lucas analyzed those statements and said, look, you stated a claim for defamation here. And again, Baskin didn't look at burden shifting. They said that you've identified it. So I think if the plaintiff here actually identified defamatory statements and malice, because otherwise I believe that the statute loses.
I pause you for a second. Do you want to finish that thought or do you want to switch over?
I just need 10 seconds.
Go ahead.
I think if the motion to dismiss right in the statute needs to have legs. And so something has to be shown in a motion to dismiss. Otherwise, the SLAPP statute, which again, SLAPP is public participation. So you're going to have a heightened standard and someone can just plead it. Like and they said in Misiev, if you can just plead around the statute becomes.
Thank you. Mr. Jackson. Okay. Mr. Taylor. Stop. 2.5 minutes.
Thank you, Judge. And actually, I'd like to reserve the opportunity to use all five, but if I finish early, I will cede that time to Mr. Cockamp or to Mr. Fraser. Thank you. May it please the court. Damian Taylor on behalf of the Appellee, Dr. William Figglestaller. I'd like to return first to a discussion during Appellant's oral argument about the Texas hoax claims. I think it's important to realize that the trial judge did in fact dismiss the Texas hoax claims with prejudice on independent grounds, and specifically insofar as those claims involved a publication that the court found did not in any way implicate the appellant. That is a decision of the trial court, which was completely unaddressed in the appellate brief, in the initial brief, excuse me, of the appellant. And so I would respectfully submit to the court that that issue has been waived. They only raised it on appeal for the first time in their reply brief. As the court is well aware, I think it's a well-established principle of law. I can cite to the court the Southeast Capital financing case. That is cited as.
Do you accept your colleague's argument that the trial court basically said that if it weren't for anti-SLAPP as it relates to FEC and Harvard statements, it would have been a dismissal without prejudice?
With respect to the FEC statements and the Harvard statements, I would acknowledge that the trial court's order indicated that those claims would be due to be dismissed without prejudice. And it was because of the findings under the anti-SLAPP statute that the court dismissed those claims with prejudice. But again, as to the
Do you believe that the shotgun pleading justification for dismissal applied to the FEC and Harvard statement claims?
Excuse me, one more time, Your Honor.
Do you believe that the shotgun pleading justification for dismissal applied to the FEC and Harvard statement?
I do, Your Honor. And by the way, the Southeast Capital case, that's 616 Southern 2nd 482 out of the 4th DCA. So on that, Your Honor, I would also submit that the court, separate and apart from any burden shifting analysis, had grounds to nonetheless dismiss the claims based on the FEC statements and the Harvard statements under the anti-SLAPP statute, insofar as there were numerous pleading deficiencies. The statute tells the court that it should try to resolve these claims under the anti-SLAPP statute expeditiously. The court was faced with, I think, indisputably speech that would fall within the protection of the First Amendment, but for the allegation that the speech was defamatory. But for all of the reasons cited in the motions to dismiss, which are not, for the most part, addressed in the appellant's initial brief, the court found that there was no cause of action for defamation stated. And so
You read that statement, that word expeditiously in the anti-SLAPP lawsuit. Do you read that as something other than as it relates to prioritizing the hearing?
Your Honor, I do. I would submit that the court in Gundell and Davis versus Michigan got it right. And that what we are really dealing with is a different type of dismissal hearing than simply a hearing on a motion.
Counsel, where's the support in the statute for that assertion? So
Your
there's
Honor,
a different, this motion to dismiss is different, apart from expeditiously, and we see that routinely with immunity cases, right? We've discussed some of those today. Where's the support for that? And I think in Gundell, and I was trying to, remember if it was a Maine statute, what other state the statute, that in Gundell, the second DCA relied on, you know, was it Maine?
Yeah.
Okay, thank you. And the Maine statute is different from ours, right? And the Maine statute addresses that burden shifting in the context of dismissal, and try as I might, I don't see that in subpart 4.
I acknowledge.
I'm gonna, as the man said, I'm gonna let you finish. but you're below where you want to be. So just as it relates to your colleague, I would anticipate that you'd answer my colleague's question.
Yes, and I would like to make one or two other quick points, Your Honor, if I may. So I acknowledge that the statute could be more clear. I still believe that when the court looks at the intent of the legislature, which was expressed in the original enactment of the law, combined with the language that is in the statute, that using the reasoning of Gundel and Mishiev, we're dealing with a different kind of motion to dismiss. But even if that is not the case, the fact remains there were grounds for the trial court to dismiss the amended complaint under the anti-SLAPP statute, and appellant did not raise the issue of whether that dismissal should have been with or without prejudice under the anti-SLAPP statute. They only attack the court's use of the burden shifting analysis. I would also like to briefly.
But how do you get into that without going beyond basic pleading rules, without going into proof? That's where I'm struggling, because what you seem to be saying, and maybe I'm not understanding you correctly, is that the independent reason outside of the second DCA's precedent that we can affirm the trial court's dismissal with prejudice is because anti-SLAPP is somehow different. And it goes back to my example of calling a campaign opponent a pedophile. Like, how do you say that that isn't defamation without going into proof? How can you just do it on pleading unless you get into the veracity of it?
Well, Your Honor, I think the answer to the question is as to how this court can affirm the dismissal with prejudice is because appellant didn't raise that issue on appeal. And there were numerous pleading deficiencies, setting aside whether or not the appellant was required to prove anything. Let's just, for the sake of discussion, concede that appellant should not have been required to prove anything. There was still a basis to dismiss the complaint under the anti-SLAPP statute based on the pleading deficiencies, and appellant has waived the issue of whether that dismissal should have been with or without prejudice. I would respectfully.
And those two pleading deficiencies, are they limited to shotgun pleading and the failure to plead malice with specificity?
Your Honor, I would say yes, using the expression shotgun pleading in the broadest sense to apply to the allegations that lumped all of the defendants together in multiple accounts, accusing all of them of making numerous but unspecified statements to unspecified third parties at an unspecified time in an unspecified format that were allegedly defamatory without specifically identifying what those statements were. There were numerous details beyond just actual malice, or more precisely, the factual basis for the actual malice that were completely omitted from the amended complaint, even after the appellant amended once, knowing that we were raising those deficiencies in the motion to dismiss the original complaint. And then, of course, appellant acknowledged at the hearing before the judge that they had pled everything that they were aware of. Thank you, Your Honor. I believe I'm out of time. Is that?
Oh, and then some, yeah. Mr. Shanine, you get an extra minute and a half on this. Oh, Mr. Kotkamp, I'm sorry, you got it. And then some.
Thank you, Your Honor. First, I would just like to quickly address the court's earlier question as to where the reply brief of those sections were. There are of course multiple reply briefs, but in the Fiegelstatter reply brief, pages 15 to 18, and in the Gall reply, pages 16 to 17, those specific discussions of prejudice versus non-prejudice are certainly discussed at length. But the important part is we already heard the argument in the concession in candor that that's exactly what the trial court had already said, and that they agree with that. And upon reversal, if this court finds that Lamb is the appropriate standard, then this court should find that, because the textual argument must triumph over a probabilistic, what I'm going to say, or intent-driven argument. That the court below conceded that, thus plaintiff fails to properly plead these claims, plaintiff's claims would be dismissed on that basis without prejudice if defendant's motions were limited to those deficiencies. But then he says they're not, because now we get to get into this anti-slap burden shift that Gundel applied. Gundel is not a problem iteration of law. The court already discussed how the Gundel decision bases its intent-driven philosophy on a main statute. But the main statute, like many other state statutes, use a different and an actual textual differential on the standards. And the Lamb Court addresses that. And the Lamb Court says, we see that and it makes sense, but making sense is not the same thing as what's written in the statute. And if this legislature had wanted to include those kind of burden shifts, these statutes were already in the books in states like Texas and Maine and Michigan and other states. They could have followed that language. They did not. This court has already addressed.
Let me ask you about the Texas hoax again.
Sure.
Just because it kind of echoes back to my first question to you in your initial argument. Have you given any thought to the damages model here? You know, like it wouldn't be sufficient, for example, to plead a claim for defamations and then have the factual assertion at the end say, I have not been damaged. Sure. You know, that would pass muster. So help me understand the damages model a little bit here.
On the Texas hoax specifically, here's what it is. Well, first of all, in the damages model, we have to understand that this was an amazingly close election. The 4 top candidates for this primary position were within 4 percentage points of each other. And the winner of that race was essentially locked into a heavy likelihood of prevailing in the ultimate election, which candidate Donald ultimately did. So even the smallest movement in the electorate was critical in these instances. So it's really easy to jump to how damages would accrue. But specifically with the Texas hoax, it's in my mind one of those interesting parts of this discussion, because the other 2 claims are straight up defamation in the style of, as this court used the someone were accused of being a pedophile. You know, that is not protected speech. That is, if you do it with the actual malice, with the knowledge of its falsity or reckless disregard, as New York Times v. Sullivan instructs, then that is not something that the First Amendment secures your ability to say. This Texas hoax issue is interesting because they've argued to the lower court, and the lower court agreed to, well, that affects a different candidate that didn't affect you. But my analogy is it's like those amazing fireworks that Disney does, where they launch a firework and it goes, it sparkles, and then there's a hidden firework inside of it. It sparkles later, a delayed blast. That's what the Texas hoax was.
But is the Texas hoax fair game here?
That's a different question than the question of how this damages work. But I believe it still is, but to the extent that this court were to decide, you know, your prior counsel who wrote the briefs should have addressed the Texas hoax separately and had a separate argument on that this court could say it is reversed as to the FEC and the Harvard, because that is the part that the judge concedes would be dismissal without prejudice, not with prejudice. In the Texas hoax, perhaps not. That's for this court to decide. But I'd like to just finish off the point there, and that's the first firework was the defamatory statement about Donald's, that Donald's had dropped out of the race, and they actually fabricated a made-up video to go with that. That was real video from 8 years prior of him dropping out of a different race. So there's no question about actual malice. And if Donald's had wanted to sue on that would be a pretty direct claim for him. But they cleverly sent it from a state that none of the candidates had anything to do with except for Mr. Ascar. And why did they do that? That delayed second blast, because after the early election day rumors, hey, maybe he's dropped out. I'm not going to waste my vote on somebody who's dropped out. Once candidate Donalds gets hold of this and starts, digging and sees the Texas, they were hoping for a second blast. So I think that it was, crafty, clever, but it's exactly the type of thing like the other actual malice statements that The same court that did New York Times and Sullivan said specifically in Garrison versus State of Louisiana that, the lie cannot be counted. That,
Counsel,
yes,
with regard to the leave to amend, you've harped on what and I've heard you state what the trial judge stated about that but for the slap, perhaps leave to amend would have been granted. What about below counsel for your client, Mr. Ascar's statement that essentially this is sort of all we have. You granted us leave to amend once, and now unless apparently we let you get through discovery, I don't think he would have much more. And that has to be considered, I would think, in conjunction with the need to resolve these cases expeditiously. What's your response?
that the court, and there's no question, the court said that without prejudice would have been the answer, but for the burdenship. The question is to what else can be added to the complaint without discovery is part of the conundrum here. That's why I've argued to this court that this is not a shotgun pleading, that this is a pleading that should have been allowed to move past the motion to dismiss stage. Now, the fact that the court below said he would dismiss it, fine. We can go back and, hopefully structure it a little better, maybe separate some parties out a little stronger, if it was like, but ultimately it's going to be very hard for not just Mr. Ascar, but any candidate or other person faced with that all lie that they must go after before they can do discovery. That would be a burden shift legislature didn't create, didn't countenance, and didn't put in text. So for all of these reasons, Casey Ascar respectfully requests this court to definitively side with the land decision so that we have majority of DCAs that now go with the textual interpretation. And once it does so, to reverse and remand with those instructions, this court feels appropriate. Thank you.
That was well argued. Well, interesting case. We'll take it from the front.